Himanshi, and today we'll be discussing the topic summary suits. So before we start, let us first try to understand the meaning of the word summary. So summary means speedy disposition of a suit without following the entire procedure, like in the case of an ordinary suit. So to study this topic, we need to get into Order 37 of the Code of Civil Procedure. Now, let us first try to understand what is the purpose of summary suits. So the purpose is twofold. Let me write it down for you. So the first is to avoid unreasonable obstruction by the defendant who has no defense. And the second is to assist in expeditious disposal of the cases. So in summary procedure, the defendant is not allowed the right to defend as of right, because otherwise the proceedings will be elongated and the court will take a lot of time to decide the case, which will defeat these two purposes of summary suits, which are to assist in expeditious disposal of the cases and to prevent unreasonable obstruction by the defendant who has no defense. So now, since we have understood the purpose of the suit, let us proceed to Order 37 and understand which all courts can take up summary procedure. So for that, we need to get into Order 37 Rule 1. So it mentions which all courts can take up summary procedure. So the first one is High Court. Second is City Civil Courts. Next is Courts of Small Causes. And the last one is Other Courts. Now, which are these other courts? These are specified by the High Court itself in the official gazette. So these four courts can take up summary proceedings: High Courts, City Civil Courts, Courts of Small Causes, and Other Courts. Now, which cases can be taken up in summary proceedings? Firstly, it should be based upon a fixed money claim and it should be based upon some document. So the document may be hundis, bill of exchange, promissory notes. It can be any document on which fixed money claim is based. So moving further, now when the plaintiff presents the summary suit before the court, what are the requirements to be mentioned in the plaint? Now this is mentioned in Rule 2. Let me write it down. So the requirements that are to be mentioned in the plaint, firstly, that the suit is under this order. Second, no reliefs other than reliefs under this order have been claimed. And third is, in the title of the suit and the description, it should mention that suit is under Order 37. So these are the requirements which are to be mentioned in the plaint, that the suit is under Order 37 and no other reliefs apart from reliefs which are available under Order 37 have been claimed. So I hope you have noted it down. Now let's move further to Rule 3. Now, when the plaintiff moves his summary suit before the court, the defendant cannot defend as of right, and he will have to apply for leave to defend within 10 days before the court. So, this is mentioned in Rule 3, and if he is unable to apply for this leave to defend, then the court can also condone this delay under Sub-Rule 7 of Rule 3. However, it is on the discretion of the court, and the defendant will have to prove sufficient cause for getting this delay of 10 days condoned. If there is any malafide or gross negligence on part of the defendant, then the court is generally not inclined towards condoning this delay. Now, this leave to defend can be granted only on the discretion of the court, and there are a few situations which the court judges before it grants leave to defend to the defendant. Now, these situations are very important. I'll just make a chart for you so that you can understand, and please note it down. Now, the first situation is where the defendant shows a good defense. So now, if this defense is proved, the defendant will be successful in the case, and here the court will unconditionally grant leave to defend. So, the leave to defend is unconditional. Second, where the defendant shows strong grounds. Now here the court does not believe that the defendant will be successful. However, he has contestable issues. Now here also the leave to defend will be granted unconditionally. Third is where the defendant has weak grounds. Now here, on the basis of natural justice, the court will conditionally grant the leave to defend. The last one is where the defendant has no defense or he has a moonshine defense. Now here generally the leave to defend is not granted by the court. However, if the stakes are high, then the court will grant the leave to defend. So firstly, if the defendant shows a good defense, and here the court believes that if the defense is proved, the defendant will be successful, then unconditionally the leave to defend will be granted. Second, if the defendant shows strong grounds and the court does not believe that the defendant will be successful here, but the grounds are contestable, then also unconditionally the leave to defend will be granted. Third, where the defendant has weak grounds, here on the basis of natural justice, the leave to defend will be granted to the defendant but conditionally. And the last one is where he has no defense, or it can be also called moonshine defense. Then here generally the court will not grant leave to defend, but if the stakes are high, then the leave to defend will be granted by the court. So now, if the plaintiff makes a claim before the court and the defendant admits his claim, and even then, if the defendant has not deposited the amount before the court, then a decree may be passed against him and leave to defend will not be granted. Now moving further to Rule 4, here if a decree has already been passed ex parte against the defendant, then can he get the decree set aside by the court? So here the same is mentioned in Rule 4, and the court has discretion to set aside this ex parte decree if it is passed against the defendant. So for this, we need to write this judgment. So it is Rajni Kumar versus Suresh Kumar Malhotra. It is a 2003 Supreme Court judgment. So for getting the decree set aside, 3 prayers have to be made by the defendant. First is to set aside the decree. Second is to stay the execution. And third is to allow leave to defend. So these 3 prayers have to be made by the defendant, and this judgment is important for Order 37, Rule 4. I hope you have written it down. So now before we end this topic, concluding here, I'll be giving you a few judgments which you can mention in the answer so that the answer looks complete. Please write down the judgments. First is Milky Ram India Private Limited versus Chamanlal Brothers. This is a 1965 Supreme Court judgment. The second one is Mechalik Engineers and Manufacturers versus Basic Equipment Corporation. Now this is a 1976 Supreme Court judgment. I hope you have written it down. So these 2 judgments can be mentioned in any question which is related to summary procedure. Now I hope you have understood this topic and you found the discussion to be fruitful. Thank you for watching. See you next time.